My name is Jennifer McGuffin, and I am the Chief Communications Officer at Romanucci and Blandin. And I would like to introduce to you today three of our attorneys. Antonio Romanucci will be our first speaker, followed by Ian Fallon. And then our last attorney speaking today will be Bhavani Ravindran. The correct spelling of all of their names can be found in the press release that was distributed this morning, along with a filed complaint. They will talk through the fundamentals of this case, the issue of hazing and sexual abuse and hazing overall. But you will also notice, please, that our clients are not present. And we would ask that you please respect the privacy of these young men and their families as you cover the story. We very much appreciate the coverage, but there are sensitivities here, which, of course, you will be able to understand. Let's get things started. Antonio Romanucci, please.
And good. Thank you, Jennifer, and good morning, everyone. Happy to see you here, but unfortunately under these circumstances, because once again, we are here because our children face tragic physical and mental life-altering events because those facilities, institutions, adults, and coaches who know better and should know better once again failed those children because they refused to know better. They stuck their head in the sand, and they allowed young men to be sodomized by varsity football players with broomsticks in a disgusting and reprehensible high school football ritual known as Code Blue. And you're going to hear more about that from Ian and Bhavani. So my question is, when will the educational community finally wake up and stop this practice of hazing, bullying, and sexual assault for the sake of bonding and a winning football record during the school year, which is what this is all about. This practice must be stopped now because we're here to announce another in a string of hazing and bullying lawsuits that not only this law firm has filed, but many others, which we've seen throughout the last 10 years. And this one is against Plainfield High School because they were complicit. The high school itself was complicit, and their football coaches were complicit in allowing varsity football players to prey on young children in the hopes to achieve a bonding experience and for the sake of a winning football record. And we will hear that some of their own football players admitted to coaches that what they did was, quote, "it was just a joke," end quote. And as we can see, this is not a joking experience whatsoever. This is something that has lifelong consequences for these young men. There should be also no mistaking in the timing of this litigation as we approach a new school year, and with football practices already in full swing, there should be some meaning behind the timing of this litigation as we put not only Plainfield High School on notice, but all high schools throughout the state on notice that any practice of bullying, hazing, and or sexual assault is prohibited and must never, ever be condoned. We'll hear that these children, after they reported their reprehensible behavior to coaches, that they were subjected to retaliation and humiliation as a result of being deemed snitches. So we are representing John Doe A and B in this litigation, and we are alleging that they had their rights violated in a number of different ways. Number one, through violations of their own high school athletic code. Secondly, through the United States Constitution by having their 14th Amendment rights to due process violated, and also through state law, the Bullying Prevention Act, which the high school coaches clearly failed to monitor locker rooms. They failed to stop this practice of Code Blue, which had been happening for years beforehand. So any denials by the administrators or coaches, which I am certain that you will hear, they will deny all of these allegations, should be summarily dismissed as a cover-up and a denial of transparency in their role, because they either covered their eyes to what was happening or they just ignored it so that it could continue to happen once again for the sake of a bonding experience and for a winning football record. And that should never be forsaken for the health of our children. So I thank you for being here today. And now I'd like to turn it over to my colleague, Ian Fallon.
Thank you, Tony. And good morning, everyone. I'm going to discuss a little bit more about some of the finer points and the factual allegations supporting the lawsuit that Romanucci and Blandin has filed today on behalf of these two students, these two survivors of sexual assault and survivors of the Plainfield Community Consolidated School District 202. The lawsuit that we filed this morning on behalf of our plaintiffs has 10 counts. The first 4 counts are, as you heard Mr. Romanucci say, are counts for the recovery for willful and wanton conduct from the school district and from the individual coaches. What that means is that the coaches and the school district were utterly indifferent or had a conscious disregard for the safety of our plaintiffs, our students, and others. That means they knew that Code Blue was happening in their locker rooms. That means they knew that they were offering a football program that had a prerequisite to membership of being sexually assaulted. Under Illinois law, that violates the law. And no student should have to suffer from that physical and emotional trauma just to participate in high school sports. The coaches at Plainfield Central knew what Code Blue meant. At Plainfield Central, students would be subjected to a pattern or practice known as Code Blue, whereby older members would start chanting Code Blue in the locker room. They would start chanting, "Go get it." They would start chanting, "Hold them down." And as they chanted Code Blue, some of the students would try to escape. They would be held down, taken down to the ground, and be penetrated by broomsticks. This is unacceptable. No student should have to experience this just to participate in high school sports in Illinois. Not only was this occurring under the watch of school administrators at School District 202, but they knew and allowed it to continue, despite knowledge that students were being sexually assaulted in their locker rooms on their property. The next 4 counts of these plaintiffs' complaint are for a recovery for their substantive and procedural due process violations. The 14th Amendment to the United States Constitution, as you heard Tony say, guarantees the right of equal access to education for students. By maintaining a football program that had a prerequisite of being sexually assaulted to play football at a high school, they denied our plaintiffs equal access to their education, equal access to the privileges of an education in the United States of America. Because they maintained such a program, not only did they violate Illinois law and commit willful and wanton conduct, resulting in the sexual assault of these 2 young boys, they also violated their constitutional rights. Finally, the last 2 counts in our complaint are for what's known as Monell claims. Under the Monell case, the United States Supreme Court recognized that an action can be maintained against a municipal entity directly for being the driving force of constitutional violations. This school district knew that this was happening to students. It wasn't just the coaches. It wasn't just the coaches and the administrators, but it was the school district itself that allowed this to happen. It was the school district itself that was the driving force of the injuries to our plaintiffs here, because they failed to eradicate this bonding practice, this right of initiation, this prerequisite to playing football at Plainfield Central. Because of that, we have filed this lawsuit, and these plaintiffs have been brave enough and strong enough to move forward in this case. For the sake of our children, we must demand better from our public schools. We must keep our children safe, and we must fight to prevent anything like this from happening again at Plainfield Central and at all schools around this country. With that, I'd like to turn it over to my colleague, Ms. Bhavani Ravindran, to talk more about our plaintiffs.
Good morning, and thank you everyone for being here. This incident has disrupted the education of our minor clients, causing them to reassess where they are safe, where they are protected, and who they can trust. The effect from an incident of sexual assault does not end with the attack itself. Our clients continue to experience embarrassment, stress, emotional and mental distress, and humiliation. Our clients continue to think of this incident often and know their peers are aware of what occurred. They have been humiliated, teased, and ostracized by their teammates and fellow students at their schools and by strangers in the Plainfield community. They have been robbed of the sense of belonging and home they had every time they stepped on the field. Our minor plaintiffs have received threats and had students from other schools and sports teams chant broomstick at them during games. They've received constant reminders on social media. This incident will be something that follows our clients as they try to enjoy a sport they have loved their whole lives. They'll try to put it behind them and focus on the game, but have been unable to do so. Nothing has been the same for them since this happened. They have had to seek new educational environments, new teams, and a complete overhaul of their support systems. The minor plaintiffs could not escape constant reminders and harassment after the incident had occurred. The mental and emotional trauma from both the incident and the aftermath will follow them throughout their lives. Hazing is not just a tradition that everyone goes through. When it escalates to this level, we must call it what it is, sexual assault. And that is something that our minor plaintiffs will be dealing with for their entire lives. This incident in itself was an invasion of our client's privacy. It took control away in a moment of unnecessary and meaningless violence. For that reason, this case has been filed as a John Doe complaint, and we would implore our colleagues in the media to respect this privacy to the extent possible and keep the names of our minor clients and their families private. Our minor clients have been courageous in standing up for themselves today, for themselves, their families, and their teammates, and they will continue to do so throughout this lawsuit. Our clients wanted to make sure that the students that came after them do not face the same painful violation of their right to bodily integrity for the sake of tradition as they did. We ask that the media help us in ensuring a change is made and that our clients are not shamed and scrutinized for their brave choice to not go voiceless. Thank you for your time. I'll turn it back to Ms. McGuffin from our firm.
Thank you, everyone. Folks, we are going to take questions now, and we do already have some in the queue, but I would encourage anyone else who does have a question, please type it into the Q&A chat portion, and we will call on you by name, and we'll activate your mic so that you can speak your own questions and ask any follow-ups that you might like. First will come from Andy Grimm at the Sun-Times. Alyssa, if you're able to turn Andy's mic on, we will let him take the floor. I will go ahead and ask Andy's question. It is, how long was the hazing going on and how many other victims might there be?
Ian, do you want to take that?
Absolutely, Tony. Thank you. So the hazing that's been going on, the code blue has been going on at Plainfield Central since at least 2014. The sad reality of the matter is that Code Blue has been a reality and has been known to to members of the Plainfield Central community for some time. We know that similar incidents happened as early as 2014, and that Code Blue has been an integral part of the Plainfield Central football community since at least that time. As far as the number of victims that there are, unfortunately, sadly, they're countless. We know that several students have been subjected to this and have been approached by some of the perpetrators of the Code Blue, and they're encouraged to just walk away from it, to just say it's just a joke. This is just what makes you part of the team. Just accept it. But unfortunately, there are dozens and dozens and dozens of victims of this practice, and our investigation will continue. We will encourage others to stand up and fight. But the number of survivors from this are countless, unfortunately.
Thank you, Ian. And we do encourage, if there are any other witnesses or individuals who know anything about Code Blue, we do encourage them to come forward and have a discussion with us. Bhavani, Mr. Grimm had another question about the prosecution. Why don't you take that one?
His question, Bhavani, is what happened with the misdemeanor charges filed against the perpetrators? Were they upgraded? And do we agree with the statements that the alleged conduct did not meet the legal definition of hazing?
Thank you for your question. The misdemeanor charges were not upgraded. There are, of course, requirements in criminal law that we do not have in civil law. We will be able to show that the constitutional rights of our clients were violated through an act of hazing. We believe that the legal definition of hazing can be reached in the civil case, as we are going to be able to conduct additional discovery that wouldn't necessarily be available to the criminal prosecutors, as our defendants also include the school district itself. We'll be able to figure out if this has been, as we believe it to be, a longstanding tradition. We will be able to identify if there were victims from years prior that we do not know of at this point, in addition to those individuals that Mr. Fallon described. We, at this time, know that the prosecutors face very different legal definitions and elements that we would not be required to address in the civil case. And to the extent that those prosecutions of juveniles have been completed, that is our understanding. There are protective orders, so we wouldn't be able to comment more on what exactly occurred in those criminal proceedings, and we would suggest reaching out to the prosecutor's office for more information on that.
Team, we have another question from Emily Rosca at Patch, asking for the exact date of this incident. And I've also taken the same question a few times over email. Is this the same incident that received media coverage back in 2019?
Ian, you want to take that for the dates, please?
I can. So the answer to the first question is October 16th, 2019. And the answer to the second question is yes. This incident received significant coverage in the Chicagoland area media and the Plainfield community media around the time of the occurrence. Yes.
Thank you all. That is all that we've got in the queue as far as questions go. We'll give everybody another 10 seconds or so in case there is one or two other that might come. Certainly you all have my email and you can reach me that way if something comes up later this afternoon. Tony, can I ask you to provide a closing comment?
The closing comment is that not only has our office been down this road before, but we have seen the devastation that this does cause to the young men who are traumatized. You know, people underestimate what bullying or hazing is. When it rises to this level, it's not just a bully or a haze, it is a sexual assault. And the allegations that we have in this complaint on behalf of John Doe A and B, they're very serious. And we want the administrators of Plainfield High School and all high schools across the region in Illinois to take these allegations seriously, because by doing so, they're protecting young lives. And that is really the goal of this litigation, is to stop this. But we've seen that it does stop for a little while and then it picks back up again. And we'll continue to do this as long as people continue to assault and harm children. The aim and the goal here is protecting kids. That's what we want to do. Thank you, Jen.
Thank you. We did take one more question in the last moment, and it is about the whereabouts of these students. And Bhavani, I know that this is a question that I think is important to you. Did they stay? Did they transfer? Or is that even something we are willing to disclose?
Our clients are no longer on the Plainfield Central team or at the school. We can't really go further into it. As we've said, we want to respect the privacy of our clients, but we can share that information. Thank you for your question.
Okay, everyone. I think that should do it for questions and comments. Again, thank you for your attention and for joining this conversation and for helping us do the right thing by these young men. Have a good day. I'm certainly available if anything else arises throughout the day. Thank you.